And welcome to the Week 6 video lecture. Week 6 is all about impeachment, and impeachment is something you might think about for the President of the United States. It is something that is called impeachment. That's a different kind of impeachment, but it has similarities. It's a way of deciding or making it so that someone has little or no credibility. So when you impeach someone, you impeach their credibility when it comes to a matter that is in trial or them as a witness. So impeachment is basically not quite calling people a liar, because you don't have to call them a liar to impeach them. For instance, you can impeach someone who's a very innocent and forthright person who's telling the truth as best they can, but they may not be able to tell the truth because perhaps they made a mistake, basically. Let's say it's an eyewitness testimony, and you don't want to say that this innocent victim made a mistake, but maybe they did, and you just have to say, okay, well, they're a nice person. They're trying their best, but they made a big mistake here. And so that their credibility of their testimony is still going to be attacked through this process we call impeachment, but we don't have to call them a liar. Now, liars, of course, are definitely people who are impeached. If they're lying about something, then they're telling you something that is false, and they know it's false. That's sufficient reason to call them liars, and you will impeach their credibility, certainly. In fact, if we can catch just one lie on anyone's testimony, generally speaking, the rest of their testimony is pretty much unbelievable unless we can corroborate it with some other believable testimony that it might be true. Once a liar, always a liar, and we can't believe anything they say because they say it, essentially, is what comes down once you actually prove that they are a liar. All right. We're also going to get into who can be impeached, and then we're going to get into whether we can impeach based on character evidence. And you can, but it's character evidence for truthfulness. For instance, if someone is a habitual liar throughout the community and has a reputation for being nothing but a liar, that is something that can be used to attack the credibility of a witness and impeach the witness, which is one and the same thing. Remember that impeachment is attacking the credibility of a witness, whether that be through calling them a liar or saying they're just making a mistake. So we can use their character for truthfulness. It's an important thing. If people are habitual liars, they may be more likely to be lying on the stand than someone who is habitually honest. All right, also going to go through evidence of specific conduct on cross-examination regarding whether that can be used as evidence to impeach somebody. And then we're going to go by evidence of conviction of a crime, whether that can be used to impeach, and it often can, depending upon the crime and the jurisdiction. We'll see that in California, for instance, you have to have at least a felony, and it has to be a conviction. And for criminal matters, it has to be not just a conviction, but a conviction for a moral turpitude crime, meaning one that indicates that the person has a problem with just following very important aspects of the law, something that shows that they are morally corrupt. So, for instance, a drug felony, for instance, just drug possession, is not considered a crime of moral turpitude. So even though it is a felony, it couldn't be used in a criminal case to attack credibility. It might in a civil, but not in a criminal, because it doesn't show moral decay, basically, and it just means someone's got a problem. All right, so impeachment is whether we can do that on based on religious beliefs or opinions is another one we're going to find out we cannot, just for policy reasons, but for all the reasons it really doesn't have very much value. It's not much in terms of value, and it's abhorrent for us to think that we can try to ridicule someone on their religious beliefs as a way of impeaching them. All right, let's get into the subject matter. Before we do that, let's just go through a couple more because I missed a couple there. We have prior inconsistent statements as one way to impeach, refreshing a witness' memory, which is another way to not exactly directly impeach them, but say that maybe they forgot something, but maybe I can help to conjure up a memory of what it was by telling them something, showing them something, that kind of thing. We're going to also think about impeachment based on personal bias. If someone has an interest in the lawsuit, for instance, of course they have a personal bias that might tend to make them want to color their testimony or possibly lie. Then there's collateral extrinsic evidence rule, which we'll talk about, in essence, whether we can use collateral extrinsic evidence to impeach someone, essentially things outside of what is going on in the case. We'll go through that in some detail. And then overlapping rules and limitations on the use of impeachment evidence. We'll go through all those. So we've got a lot of things to cover, so let's get going and get into our impeachment work. Again, impeachment is attacking a witness's credibility. Again, you can do that by showing that they're a liar, not just calling them a liar, but showing that they're a liar. Also, that just by the fact they made an innocent mistake, and therefore their credibility is not that good. So we have to remember that it's not always about calling people liars, and you don't have to do that. That's what you need to know. It's just a way of attacking the reliability of their testimony is another way to look at it. Some witnesses' testimony is very, very reliable, and others may be less than reliable, and for reasons either that they are lying or that they just made a mistake. So if we translate, you do not think the witness is telling the truth or the whole truth, and you want to expose this to the judge and jury. That's essentially what you're doing. You don't think that they're telling the truth, whether that be through intentional act or an innocent mistake, and you're going to expose the fact that they're not telling the truth to the jury somehow. That's what you're doing through the impeachment. All right, anyone in a trial can attack the credibility of any witness. This is kind of important because you could bring on your own witness and attack their credibility. And you think, what in the world are you putting on a witness if you're going to get up there and attack their credibility? But it sometimes is necessary. For instance, I have many cases when I was a prosecutor of domestic violence. 99.9% of the time, when I had the wife victim on the stand, she would invariably say that it never happened, or that she was the aggressor and that he had a right to defend himself, and so he didn't do anything wrong, all of which is false, an absolute lie, and for very good reasons they're lying, because they just found out that hubby's been in the jail and they don't have any money coming in because he can't work, and they want him out so he can make money and pay the rent. And so they'll do what they need to do to get him out of trouble. He may have also made up to them by that time and said he's never going to do it again, that kind of thing. In any event, they will get up there and lie almost every time. So what I have to do is put them on the stand and say, go through the questions, on such and such a night, did someone hurt you? And they'll say no, it never happened. No, really? Well, the police found you with this, swollen lip and cut on the side of your head and that kind of stuff, and they're going to say, well, I fell down the stair and that's what happened. That's sort of what goes on. And then I say, okay, that's interesting. You say that you fell down the stairs. Well, isn't it true that you told the police while crying that this man had beaten you and beat you badly that night? Isn't that what you said to the police? Well, they can say yes or no, because I'm going to prove that they did say it to the police, because the police officer is going to come up and he's going to testify as to what she said and what her emotional state was at the time. And then I'm going to bring on the 911 tape where she's screaming into the phone, help me, because he's trying to kill me, and extremely emotional and upset, obviously. And please get here as fast as you can, because he's going to kill me if you don't get here. This kind of stuff. So I'm going to attack her credibility left and right. And the jury's going to see through all that because they know why she's lying. They know that she's quite capable of lying under the circumstances, and that all the evidence is pointing towards exactly what originally happened, and that was that hubby beat up his wife, and she's now lying on the stand. So that's sort of what has to happen sometimes, is you sometimes have to put a witness on because they're the victim, and give them a chance to lie, and then prove to the jury it's all a lie. It does happen. And occasionally that'll happen by surprise, that someone might do that to you. After telling you through interviews what was the case, now they get up on the stand and they say something completely different. You'll have to attack their credibility right then and there because you've already put them on as a witness. All right, so let's look for some of the things you can use to attack credibility. Now, Federal Rule 608 says you can attack the credibility of a witness by their character trait for truthfulness or its opposite. Now, you wouldn't put on their character trait for truthfulness if you're attacking credibility, obviously. you're going to put on their character trait for being a liar. And there are people out there, you probably have heard of a few or know of a few who people just tell you left and right, don't even believe a word that person says. They lie all the time. It's just a well-known fact throughout the community. This person's just a liar. Well, you put that on as evidence to try to give the jury more information about whether they should believe this person or not when they're testifying. Next is certain prior convictions of crime. Yes, there are certain convictions. We'll go through what those are here in a minute under Rule 609. And then there's prior inconsistent statements under Rule 613. What that means is it's like the domestic violence victim. She comes up, she testifies that the reason why she had these injuries when the police came was because she fell down the stairs. Well, okay, well then I'm going to ask, isn't it true that you told the police that your husband beat you badly that night, and that's why you were beaten, that you had all these injuries? And she may say yes, you may say no. It doesn't make any difference because I'm going to prove up the inconsistent statement, whether she admits it or not. And that prior inconsistent statement is deadly. What is she doing telling the police at the time this was going on when she's called for their help to try to help her out of a really bad situation? Why would she lie and say that hubby had just beaten her up? There's really no reason. If she'd fallen down the stairs, she would have called an ambulance. She wouldn't have called the police. And the 911 tape pretty much cinches it. All right, other acts, we'll go through those under Federal Rule of Evidence 401 and 4 through 404. There are other acts that can be used to prove up ways of attacking credibility. Also, personal bias, prejudice, or self-interest. These are, obvious. If someone has personal bias, prejudice, or self-interest, they are definitely going to be someone who might color their testimony and or might lie. So that's important things for the jury to know. And so that's part of attacking their credibility. Next is capacity to perceive, recall, or relate. That's basically evidence we put on to show that either they have a problem with their perception, which means maybe their eyesight isn't that good, or that where they were or they said they were, it was impossible or very difficult for them to have seen what they say they saw. Or perhaps it's their recall, meaning it's not that they didn't see something, but what they're recalling is different from what they actually saw. That is very, very common. And or maybe not being able to relate it well. It means they can't describe it very well. So maybe we might have to attack their credibility because they're just not able to describe what they were seeing sufficient for us to really conjure up an image of what it was. And of course, there's intentional lying. That's Federal Rules 401 through 403. And then other contradictory evidence. Evidence, we can actually put on evidence. Someone says that such and such happened on a certain day. We can bring up evidence showing that it never happened. That did not happen. Here's the evidence that shows that it didn't happen, and lots of it, perhaps, maybe often circumstantial evidence. That's good ways of attacking credibility, sort of in an indirect way. It's proving the opposite of what they say happened, and that's good evidence that would attack someone's credibility. All right, let's look at the methods to attack credibility. Let's look at several ways to attack credibility. First is impeachment by omission. And next is impeachment by character evidence. The next is impeachment by evidence of bias or interest. Impeachment by proof that you lied to the judge. These are all videos, by the way, in your materials that I want you to watch because you'll see how it actually happens. And then when you see how it happens in court, you'll get an idea of what's going on. If someone doesn't say something that they should have said, that's a pretty good idea that they're hiding something. And if they're hiding something, that means they're probably hiding more than one thing. And they have reason to want to hide it because they're not telling you the truth. Character evidence, again, is another one. We'll see how that actually happens in court when you look at these videos. So please do watch these videos. They are really worth your time just to help you to understand what we're doing when we're attacking credibility. Because remember, just because somebody puts on a witness does not mean that the jury is going to believe them or that they should believe them. And it's our job, if we're on the opposite side of that witness, often to attack their credibility because we don't believe they're telling the truth. And we want to bring on all the evidence available to show the jury that they are not telling the truth. And this is what this is all about. Now we're just talking about methods of getting the job done. All right, you cannot bring up evidence of good credibility of your witness until the credibility of the witness has been attacked. That's Rule 608A. This is a good rule. If no one attacks your credibility of your witness, there's nothing, they don't bring any contradictory evidence, they don't bring on any of the methods of attacking credibility. They just basically, leave the witness the way they were, and like, okay, well, this person had to say what they had to say, and you don't do anything. Well, if that's the case, then you can't bring up evidence of their good credibility, meaning we will presume that a witness is credible until the contrary is somehow proved, or at least presumptively proved, so that we now have to rehabilitate them. So, for instance, if you have a witness who has had their credibility attacked in some fashion, then you have the right to put on what's called rehabilitation evidence. That means to rehabilitate their credibility, put on stuff that explains whatever evidence was brought up by the other side in such a way that it either neutralizes or mitigates it, so that they're not quite as incredible as the other side thinks they are. So we can always rehabilitate them once their credibility has been attacked, but we can't do that. We can't say that they are an honest person, for instance, until their honesty has been put into issue by the other side. They have to first attack the credibility before we can put on stuff of their credibility. And that's because we presume everyone's credible until there's something out there suggesting that they're not. All right, so how to prove character for truthfulness or its opposite. How would you do that? If you want to put that on as evidence, you want to put on the reputation of the witness for truthfulness or its opposite. How would you do it? There's really two ways: opinion evidence or reputation evidence. Opinion evidence would be someone who knows the person enough personally. They've actually had interrelationships with that person enough that their opinion would have some value on whether, for instance, they are an honest person or whether they are a dishonest person. I remember having a case on a DUI where someone brought up a character witness for the defendant, which they can do, by the way, in criminal cases, even though their credibility has not been attacked. That's just in criminal cases and just for the defendant. But on an opinion, this guy was very, very honest, and this person had known the person for 20 years, never been dishonest in any time in that 20 years. They were friends. They interrelated quite often. And then I asked the question, well, did this person ever say something that was true that was very difficult for them to say was true because perhaps it would put them in a very bad light? And the guy said, oh yeah, he's done that. Next question was, what was that? I wanted to ask, and the judge actually interjected a objection and said, no, I'm not going to let you get into that. I think the judge sensed what it was. Is probably he admitted to his friend that he'd had an affair, and he didn't want that brought out since the wife was in the audience. So one of those things that I had some really juicy material there, and I was not allowed to bring it out. But that's an example of an opinion of it. Someone knows them well enough that their opinion means something in terms of their ability to be truthful or its opposite, and that is good evidence. And then reputation, of course, reputation in the community, and it's the old question: Have you heard? Have you heard about this person's reputation for truthfulness or its opposite? Quite easy question. And if they know about this person's reputation, even if they don't know the person, but they know of their reputation, they can testify to it. And essentially, that's all hearsay. But we know that reputation is usually deserved and it's earned in a community based on the way a person acts. In essence, you make your reputation based on how you act in the community. And so if you are an honest person, people will pick that up and they will be able to say, yeah, that's a very honest person. That's what they have a reputation for. Or if you're a liar, it's going to come out you lie to lots of different people and they all get together. I mean, not get together, but the grapevine sort of works its way. And everyone says, don't ever believe this guy because he's a big liar. And that gets around to everyone in the community. Now you got a reputation as a liar. So reputation, goes through the grapevine, and it sort of gets its way. It works its way through everybody's circles, and you're known about, even if people don't even know you, or have perhaps never even seen you, but they know about you. That happens all the time. So very easy. But remember, we can't get into specific acts of dishonesty, for instance, to prove a character trait for truthfulness or its opposite, or go through and ask for specific traits of truthfulness either. Either way, we can't use specific incidents where a person was very truthful, or specific incidents where they have been very much a liar, because again, we're going to get into a separate trial. into those things. That's why it's just forbidden. Because otherwise you have to prove that a person said something, you have to prove that it's a lie, and now you have a second trial, all within this one trial where we're trying to see, see something else. And it's very, very inefficient, very very misleading to the jury. They're gonna wonder what trial are we in here. That's gonna be a 3-ring circus pretty soon, and everyone's confused about what's going on. All right, so let's look at Rule 608. Allows a judge discretion to allow a witness to be cross-examined about specific past conduct for the purpose of either attacking or supporting the witness's character for truthfulness. Now, what this means is that I said before, you can't use anything other than reputation or opinion, but 608B does allow a judge discretion to allow a witness to be cross-examined about specific past conduct, specific acts, to support either that they were a truthful or a liar, truthful person or a liar. If the witness does not admit the misconduct, then the questioner cannot proceed further and prove up that the misconduct actually occurred, and cannot use extrinsic evidence to prove up misconduct used to impeach the witness. Again, the reason for this is you're going to have another mini trial in the middle of a trial, and especially if you have more than one incident that you want to bring up, you're going to have multiple mini trials within this overall trial. You're going to confuse the heck out of the jury about what was this case about again. We're talking. Here's this guy was supposedly lied on a certain occasion. Let's say lied on his tax return or something. I thought this case was about a breach of contract, and now you got in this guy lying on his tax return, and we got to figure out whether he lied on his tax return to figure out whether he's credible or not. It's really, really hard for juries to understand and keep track of this. It's just it gets so confusing that they'll exclude it. But they have the discretion to allow it. And so if it's a real good piece of evidence, and especially if the person admitted that that yes, that misconduct happened, it could be very, very usable evidence by the jury. It could be very, very valuable evidence for the jury. Because if someone lies on their tax return, they're a little bit on the edge in terms of whether they could be believed, since they're signing under penalty of perjury. If they think they can't be caught for lying, it shows that they are willing to lie. So it could be very good evidence. So the judge has that discretion. What'll happen is you'll have to tell the judge what evidence you have, and that you want to ask the witness about that evidence. The judge will say, okay, fine, ask him about it, but you're not going to be able to go in and prove it up. So if it's said, and you ask him, didn't you cheat on your tax returns? And the guy says, no, I didn't. And that's as far as you're going to be able to go. So you got to be really careful about that as to whether you want to use it at all. All right, so even if the witness denies the misconduct on the stand, you might be able to get in evidence of a prior inconsistent statement where the witness admitted in the prior statement that the misconduct occurred. So you can't use extrinsic evidence. I mean, you can't prove up that they lied on their tax returns through this extrinsic evidence of the tax return itself, all the accountings that would go on necessary from that person's own financial situation, all that kind of stuff. You can't get into all that stuff. But if they happen to have admitted the prior act and now it would be a prior inconsistent statement, then we can get that in, because that's easy. That takes 3 seconds to put on. Someone saying, you ask the person, have you ever talked to this person before? Yeah. Did they talk to you about this incident that happened when about him cheating on his tax returns? And oh yeah, he talked about that. What did he tell you? Well, he told me he cheated on his tax returns last year. Okay, well, you just got the statement on. There it is. He just admitted it. And previously in his testimony, of course, he denied it. But now we got him admitting it in a prior statement to his friend. That's pretty good evidence. And it's real simple, easy, doesn't make any mini trials involved. And so we'll allow that in. The misconduct must evidence the character trait of untruthfulness to be used. You can't use misconduct that would be having nothing to do with untruthfulness, for instance. So perhaps misconduct might be, something like he drinks too much. He comes home from the bars drunk every Friday night. Some people might think that's misconduct. Now, if he's in a car, certainly it'll be very big misconduct. But even if you got even a DUI is not going to indicate that a person is untruthful. It means they've got a real problem with drinking, and they've got some problems that might end up causing someone some real grief by running into somebody when they're drunk. But it is not it's not going to tell us whether they're a truthful person or it's not or not. So all right, so what kind of things would be misconduct that would be character traits for untruthfulness? Theft, perjury, forgery, embezzlement would be any of those. It does do any of those things. That's why, for instance, that when someone signs a tax return and they know that they're lying on it, that's perjury. It's also possibly theft from the government. Taking money under false pretenses, that's fraud, certainly. Bribery, swindling, anything that means trickery of any kind, where people are tricked out of something, a crime of that kind. Yeah, it's the typical theft type situations. Those would be character traits for untruthfulness. So in essence, those are people who actually often trade on untruthfulness as a way of making money. Forgery, of course, is another one. They're making up documents that don't exist by forging a signature, that kind of stuff. All right, let's look at impeachment by evidence of conviction of a crime. Misconduct resulting in a criminal conviction can enable us to use the conviction for impeachment purposes. Under Rule 609, any felony may be used to impeach a witness, subject to, of course, Rule 403 balancing. Because it's possible, for instance, you may have had a felony possession of drugs when you were 18. You were an adult, so it became an adult felony. You're now 65 years old, never had a problem with drugs since then. You've been a model citizen. No indications whatsoever that you had any problem with truthfulness or with drugs. That is a good reason why you're going to see that kind of felony kicked out of the case. You're not going to be allowed to use it to attack a person's credibility. Rule 609A2 allows any crime that proves an act of dishonesty or false statement by a witness. Now, that's not true in California, because what Rule 609A2 would allow is a misdemeanor petty theft. Yeah, that's kind of a small crime, but it is one showing that people, have a problem with, some of our important laws. I mean, certainly theft is a dishonesty type crime. You're dishonest if you go out and steal things, even if it's a small amount. The only difference between a felony and a misdemeanor and theft crimes is just the amount you steal. So that's a good one. And also any kind of perjury, any kind of making false statements, even making a false statement to a police officer, which is a misdemeanor in California, could be used in federal court to attack the credibility of a witness. It cannot in California. California, in civil actions, you can use any felony. In criminal actions, you can only use a felony of moral turpitude. So in California, for criminal cases, it has to be a felony and one that indicates dishonesty. So it has to be something like a perjury, grand theft, theft by fraud, embezzlement, those kind of things. Then you got someone who can impeach in California in a criminal case. All right, rehabilitation. The opposite of impeachment is rehabilitation. If a witness's credibility has been attacked, well or not so well, you can then rehabilitate the witness, that is, to restore or rebuild their credibility after they have been attacked. Now, generally speaking, you can't do that. In fact, you really can't do that at all. You can't rehabilitate until you've been attacked. Otherwise, we have this presumption that people are telling the truth unless their credibility is attacked. And if there is attack, then we allow you to rehabilitate it. So once your witness credibility has been attacked, you can use the evidence of reputation or opinion to rehabilitate your witness, and you can also use other evidence as well. Anything that will tend to rehabilitate the credibility of the witness can be used, including prior consistent statements. So if someone has said the same thing every single time, that's evidence indicating that they may be telling the truth because they've been consistent in their testimony rather than inconsistent. All right, so that's about it. Just realize that you can use the same tactics on the opposite side of attacking to rehabilitate. You can use the character trait of honesty or truthfulness to rehabilitate. You can use the absence of any bias or interest in the case, You can use extrinsic evidence that you brought in to the case that proves that what this person says is true as corroborative evidence that would rehabilitate, and so on. So it's just the opposite. So just realize that it is the opposite, and you'll understand what rehabilitation is. Just remember that you cannot rehabilitate if you have not been attacked. All right, that's it for credibility of witnesses and an impeachment of the credibility of witnesses and the process that we go through that. Again, please do look at those videos. Again, it'll help you immeasurably to understand exactly what this stuff is all about. But do remember that there are rules about how we can impeach and how we can rehabilitate, and that's what you want to know. All right. So again, if you have any questions, feel free to give me a call.